Pardon?
If it actually was about my parents mailed it to me, because I bet you won't hear a word.
Oh, that's kind of right. At least doesn't have it's not silver and blue with a star on the base.
Oh, if you're really going to take it for a shot, I'll upgrade next week. That should clear most of the fine on this record.
That upgrade never happened?
Well, got about half of it and failed.
Oh. Is it supposed to speed up the response time and everything?
And fix webmail and use a better phone client. Much more improvements and features too.
I'll tell you, as much as I gripe about Google as I work, the web-based version of it is better than most other programs. And simulating how it functions on a desktop.
And the newer one actually looks
Like you're on your
like
desktop.
a regular desktop one. It's pretty slick. You're also like where you're streaming. Yeah.
Adams or Scotty from Star Trek. Yeah, it should take me about 4 hours. I was like, I'm done.
Oh, that's why I want to come back to about that ad hoc thing too. So, you do it somewhere.
Okay.
Have a little bit of time.
Seems odd that you would be ordering people that are fired.
Well, so,
I mean, you shouldn't have Minardi's name in there, you know.
you know, she'll, I'm just gonna delete her. She's one of the people. Downside is especially. They're still, they still have some files associated with them.
Well, you know,
Yeah, but, well, yeah, because she's working contract, yeah. But, yeah, we found out somebody that has documents associated with it. You can find it if you know the look. But routing functions. So I'm seeing if there's, but I think I can.
you're just substituting like Sandy or something.
That's part of what I'm gonna try to do, and then Ryan gave me some other ideas to try to send a whole launch and screenshots and stuff. Anything with it goes. We should do something. Yeah, I didn't really quite push on way back then, so he said something, I was like, yeah.
And one of them, I don't know how to
You're not really there. No, it's sure only other stuff. I'm not really either. Send them something.
You know, I'll tell you that I call them, I'm sitting up in the circle. I literally just poured it in my coffee, and I literally just pulled my bagel on the toaster. And it's sitting on my head, so sitting down, oh, so now my coffee's getting cold. Yeah, right here. And it was, that was happening.
All rise, please. 25th Judicial Circuit Court for the County of Marquette is now in session. Your Honorable Judge Jennifer Mizuki is presiding.
Have a seat. All right, we are on the record in three matters, People versus Cole. These are Tuesday 58768, 59517, and 59518. The first matter is scheduled for a sentencing this morning, and the other two are set for arraignment. Mr. Griffin is here in the courtroom on behalf of the people. Appearing by Zoom is Mr. Rickard on behalf of Mr. Cole, and then Mr. Cole himself from the Marquette County Jail, and also probation agent with Cody. Counsel, I guess before we proceed here, what is the status of these two new matters, and are they related to the disposition of the existing case?
The Honor, they're not related to the disposition. I don't know, there was a plea offer made on the new cases. I don't know what the intention is of the defendant.
And I guess I inquire of that because if there's an expected resolution of that soon, I wonder if it might make sense to have one subsequent sentencing, but obviously we don't know what the intention is there. Mr. Rickard, what's your understanding?
We held the prelim, Your Honor. I don't know of any resolution. We're not entertaining any plea offers at this time.
I'm sorry, I didn't hear you very well. Could you repeat that?
I said we just went through the prelim not too long ago, Your Honor. There's no plea offer that's been accepted.
All right. And so, is it your desire then to proceed on the sentencing this morning from Mr. Cole's standpoint, Mr. Rickard?
Yes, Your Honor.
All right, let's do this then. Let's see. Mr. Cole, this is Judge Mizuki. Are you able to hear me?
There's a slight echo here. Here.
Yeah, we are getting some echoing here this morning. What I'm going to do, Mr. Cole, is arraign you on some new charges, and then we'll go ahead on the sentencing on the other matter. Are you able to hear me any better now?
I guess it's better. A little bit. It's still a slight echo. It's hard for me to catch. Yeah, it's got to come here.
Let me try muting everybody else and see if that helps at all. We had some difficulty with our connection yesterday as well. All right, Mr. Cole, this is Judge Mizuki continuing here. We've tried muting the other participants to see if that helps with the echo. How is our connection now?
It's still about the same.
Certainly we'd like to proceed, but it is important, obviously, that Mr. Cole be able to hear well enough. I don't know if the Sheriff's Department personnel, is there any adjustment that you could make? I'm not sure where the issue lies, but we did have some trouble yesterday at one point as well, and maybe it's us.
I don't know anything that I could do to help it.
Well, counsel, I guess I would look to you. I mean, these are the options. We can't proceed with Mr. Cole on video. We can't hear very well, and I mean, obviously, this is part of this. We have these two new matters, and then we have a sentencing scheduled on the other one. We can get a new date for all three things. We can have Mr. Cole brought over here, although that's not necessarily a desirable option. What's your pleasure, Mr. Rickard?
Whatever works out for Mr. Rickard.
Mr. Rickard? Go ahead, Mr. Rickard. What's your preference here?
We might as well adjourn, Your Honor, so we can proceed in person.
All right, we'll just get these scheduled for a new date. Mr. Cole, I apologize, but we also have these two new matters, and it may make some sense from an efficiency standpoint to deal with them all at once. I want you to be able to hear, and I'm just not sure that you can hear well enough to proceed here this morning. So we are all set with Mr. Cole.
Thank you.
bring us to the Hassel matter then, Mr. Jennings?
Your Honor, I've tried to call my client this morning. I left a message for her, and she's not here right now.
Well, hold on just a minute.
Oh, I'm sorry.
We're on the record in file 19-58608. This is People versus Hassel. Mr. Jennings is here on behalf of Ms. Hassel. Mr. Griffin is here on behalf of the people. This is set for sentencing this morning. Mr. Jennings, you were saying just before I stated the case name and so forth that your client is not here. What efforts have you made to reach her today?
Say again?
And what efforts have you made to reach her this morning?
I did call her this morning and left a message on her voicemail. I'm not sure if she's on her way here or not. I'd like to note that sometimes it takes a little while for people to get through the courthouse because of COVID things in place. So,
Have you met with her prior to today?
I have met with her by video, not recently in the last week or so, but at least a couple weeks ago.
I mean, have you gone over the PSI with her?
Yes, I have.
Okay. All right, then why don't, I know you have another matter here, and let's just move to that one, and then we'll see if she appears. We can certainly proceed on this. So is Mr. Ludi ready to proceed?
Your Honor, I just got a text from my office about Mr. Ludi. I was told by the sheriff's deputy that he would be on his way over here, but I haven't had a chance to contact my office about it. I'd like to be able to try to give him a call.
So he's not here?
He's not here.
But you understand he's had some contact with your office this morning?
I just saw the text that Jacob Ludi didn't get a chance to really read the text.
Okay. All right. Well, then I'll move to the next matter, and then why don't you come back up once you have some more information about either one of those, okay?
Okay, thank you, Your Honor.
All right, Mr. Crowley, how about Mr. Doherty?
He is here and we are ready, Your Honor.
All right. This is file 2059153, People versus Doherty. Mr. Doherty
Right
is
here.
here with Mr. Crowley on his behalf. Mr. Griffin on behalf of the people. Mr. Matter is appearing by Zoom from policeman Pool, and this is set for sentencing today. Counsel, prior to today, have you had a reasonable opportunity to review the pre-sentence report?
I have, Your Honor. My client has been provided a copy. He's had a chance to read through it as well.
Any challenges from the people?
No challenges.
Any from the defense?
None, Your Honor.
Go ahead with argument, Mr. Crowley.
Judge, in all fairness, I think that we've been here recently enough, and I know that the court is familiar with Mr. Doherty. He's participating in the drug court. I don't really think that I have a whole lot to say. I would ask that you follow the recommendation. I think that he's doing an admirable job. I think, I mean, I don't want to sound, condescending, but I'm proud of him. I think he's doing a good job, so thank you.
Mr. Doherty, is there anything you'd like to say?
I guess nothing besides, as far as what the plea agreement goes with no upfront jail time. I really appreciate it because of me participating in drug court and everything's been going good, so I don't really see jail being a good suit for a punishment as of yet. Unless I mess up or anything, I would understand that then.
All right, Mr. Griffin?
Yeah, we share Mr. Crowley's sentiments, and I think it's a good example of somebody who's doing well. I think he's very deserving of going upfront jail, so I support the recommendation.
All right, thank you. The guideline range here is 0 to 17 months. There's no challenge to that. And this is before the court on a sentence agreement that contemplates probation without upfront jail so long as Mr. Doherty continues to perform well with the other matter that is before the court. And as Mr. Crowley suggested, the court is very familiar with Mr. Doherty's progress, and Mr. Doherty, as I've observed before many times that you've been in court, you've been doing a really good job. And I know that you've been juggling work and a lot of responsibilities, and you've showed up for everything, and you have completed treatment, and I think you're very deserving of this agreement. We've also talked about your progress in the other proceeding and in the report that you should continue to meet all your appointments, and especially just keep in mind the need to be honest. You've been doing really well. It is a long road, and if you're encountering problems, the drug court team is here to help, and Mr. Matter would certainly be amenable to giving you some redirection if that's what you need. So if If you keep doing what you're doing, I'm confident you'll be successful, and I will sentence in accord with this, these recommendations, which are set forth in the report and contemplate a 12-month probation term with a 6-month jail sentence, but that is suspended pending compliance with the conditions of probation and the drug court program, and then the financial obligations and driver's license suspension are ordered in accord with the recommended provisions. I also have signed an order for fingerprints. Apparently they need to be collected, and this just has them to be done before tomorrow. So today, as soon as you leave the court, you got to go to the sheriff's department to get that done, Mr. Doherty. And I'll give you a copy of that order to take with you. And then also, I would just advise you that your conviction and sentence is the result of a plea, and you have the right to seek leave to appeal your conviction and sentence. And you also have the right to
This is your copy. Initial here, please.
And if you want an attorney to represent you, you couldn't afford what I'm appointment for you at public expense. If you know, originally 42 days. And you know, so you get that order back. I signed 2 originals, which I don't typically do, and then I changed this.
Your Honor, for the record, my client has initialed and I've returned to the court. He has his copy. Thank you.
That's what we take to the sheriff's department.
Mr. Matter, any specific instruction for Mr. Doherty? I think you're pretty acquainted with his progress on probation.
No, I have nothing further, Your Honor.
Anything further on this matter, then?
No, Judge, thank you.
Okay, Mr. Doherty, you're all set. Don't forget to go right over to the sheriff's department.
All right, thank you.
And then, are you ready on the Quinlan matter, Mr. Crowley?
I don't know what you're talking about, Your Honor. I'm sorry. I don't know that I have a Quinlan matter on my docket. It's possible to one of the other attorneys in my office. I'd be happy to look into it.
I have a sentencing this morning on Lindsay Quinlan.
I do not believe that that's my client, Your Honor, but I will check with my office if you'd allow me to step out and I'll find out.
Mr. Ruiz, how about the Quinlan letter? On the record in People versus Kinsel, this is file 20-59230. Mr. Kinsel is here with Mr. Ruiz on his behalf, Mr. Griffin on behalf of the people, and Mr. Cody is appearing by Zoom in place of Mr. Erkins. Counsel, prior to today, have you had a reasonable opportunity to review the sentence report?
Yes, Your Honor.
Yes, Your Honor.
Any challenges from the people?
I have no challenges. We have a stipulation as to OB3 based on Mr. Cruz's challenge.
And so what is the stipulation then?
Would be scored 0 points, Your Honor. Although there was an injured victim, OV3 being a McGraw variable, would not apply to the R&O.
And counsel, does that change the, grid?
It does not, Your Honor.
All right. All right, so this is a D-grid offense, and the PRVs would be unchanged. The total OVs would be 25 points, which continues to be a level 3, so the relevant cell is not changed. Mr. Cody, do you have that challenge that OV3 should be 0 and the total OV is 25?
Yes, Your Honor.
Oh, thank you. Further challenges, Mr. Ruiz?
No further challenges, Your Honor.
Go ahead with argument.
Your Honor, I just asked the court to follow the recommendation. I think this is a quintessential example of someone having an overdose on very dangerous drugs. Mr. Kimsel is very lucky that this did not turn into a situation where someone was hurt. And you can see, Your Honor, one of the things that the court's not aware of, and I don't even know if Mr. Griffin or Mr. Cody's aware of, but prior to the prosecution even desiring to enter into any type of negotiations, a condition of us discussing the matter was that Mr. Kimsel was to review the body cam footage of the entire incident that happened that night. And I think that that was a very good choice on behalf of the prosecutor's office, because it forced Mr. Kimsel, even though he was already sorry and remorseful for his actions, it really forced him to confront what he did. I think upon reflecting on that, he understands that he should never put himself in that type of situation again, Your Honor. But given that he is young, hardworking, employed, has a bright future ahead of him, and for those reasons, we do believe the recommendation is appropriate.
Thank you, Mr. Ruiz. Mr. Kimsel, is there anything you'd like to say?
Besides, thank you for the deal you've given me. I am very sorry that any of this has had to happen, and sorry to the police department and the health officials that had to take care of me that night. None of this will ever happen again, and thank you.
Thank you, Mr. Kimsel. Mr. Griffin?
Yeah, we support the plea agreement. It's, as Mr. Ruiz stated, it is our hope that this never happens again, and that's part of the reason why there was basically a shame factor, which I think came into play, which is going to play a positive role in this young man's life. So I think it's an appropriate resolution.
The guideline range is 0 to 9 months, and the one challenge does not affect that. This is before the court on an agreement for a disposition under the Home Youthful Trainee Act, which contemplates probation without a conviction, and the recommended term is 12 months. There are various recommendations for conditions of this probation. And they do include a jail term of just 1 day with credit for 1 day served, and then various other financial and programming conditions of probation. I first of all will indicate that it does appear to the court that this agreement and recommendations are appropriate, and I will sentence in accord with them. I think, Mr. Kimsel, there are a couple of things that stand out here in the court's analysis, and as the attorneys have addressed here, there certainly seems to be a lot of understanding on your part about, first of all, what could have happened and didn't, and then second, the situation that you put a lot of other people in. And I appreciate that you have the maturity to recognize the impact that your behavior had on other people, and the burden that was to the healthcare officials and law enforcement. The other thing is that, you're here at 20 years old. It's fairly clear that while you obviously used a substance that you should not use, and a quantity of it that caused this kind of behavior, it's important for you to really contemplate at your age that you and substances don't mix. And that can be a difficult lesson to accept when you're as young as you are, but I think that that is the reality for you. And so I'm hopeful that you can maintain the understanding of the behavior that you engaged in, and that you don't want to do that again. And I think that you seem sincerely regretful and committed to that. I do encourage you to keep in mind how you feel right now dealing with this, so that in the future when you're making these choices, you make the right ones. This kind of probation is designed to give a person like you the opportunity to avoid having a felony conviction, and I think that your attitude and your lack of history really do make you a very good candidate for that. So I will assign you to a term of probation under the Home Youthful Trainee Act for 12 months. It is without entry of a conviction at this stage, and is subject to all the conditions that are in the pre-sentence report. You will get a separate order that goes over all of those probation conditions that you'll be reviewing and signing. Make sure that you read them carefully so you understand what you need to do and not do to have the benefit of this kind of probation. Mr. Arkins would be the probation agent. Mr. Cody, are there specific instructions for Mr. Kimsel of what to do when he leaves here today?
Yes, Your Honor. The instructions for Mr. Kimball are to call Agent Arkins on Tuesday, October 20th.
And Mr. Kinsel, do you have his number? You do?
Yeah, it's on my phone.
So you should call him on Tuesday, that's a typical report day. So make sure you contact him if if you lose his number, if you're having trouble, call your attorney and we'll make sure that you get the right information. So contact him Tuesday and then he'll let you know what to do from there.
Thank you, Your Honor.
Mr. Griffin? All right, the prosecutor is presenting a motion to dismiss counts 2 and 3, and I'm signing an order to that effect. Do you have any questions, Mr. Kinsel?
No, Your Honor.
Anything further, counsel?
No, Your Honor.
Okay, you're all set. Thank you.
Are we calling it Wilson?
We will, but just hang on a second. Mr. Jennings, is that Ms. Hassel with you?
No, it's Ms. Quinlan.
Oh, okay, let's go ahead with that.
Okay, you sit in that chair right there, okay?
This is People versus Quinlan, file 20-59155. Ms. Quinlan is here with Mr. Jennings on her behalf, Mr. Griffin on behalf of the people, and Mr. Cody from probation and parole is appearing very soon. This matter is set for sentencing today. Counsel, prior to today, have you had a reasonable opportunity to review the pre-sentence report?
Yes, Your Honor.
Yes, Your Honor.
Any challenges from the people?
No.
Any from the defense?
Yes, Your Honor. I do apologize. I usually would file a sentencing memorandum, but I do have a challenge to OV 12.
Go ahead.
Thank you. Your Honor, OV 12 was scored at 5 points by the probation officer. And there's 2 different categories for OV 12, but I'm assuming it's the one that says 2 contemporaneous felonious criminal acts involving other crimes were committed. And going through the description of the offense, I trying to figure out what the other crimes were that were committed. And it does appear that she was found with different drugs on her, but I can see there's only one instance where Ms. Quinlan was committed one other crime, but I couldn't find 2 other crimes. And so I'd like to ask that the court score that at 0 points. As far as the guideline range, to move the guideline range from the offense variable level from offense level from 2 to 1, and the guideline from 0 to 6 months. From 0 to 9 months to 0 to 6 months, and would not have an effect on the ultimate recommendation.
Let me I will give you the opportunity for further argument, but it might give some context to the arguments. If Mr. Cody, can you articulate the source of the scoring for OV 12?
Your Honor, I'm looking into it right now. If I could just have 1 minute to look a little bit further.
Yeah, that's fine.
Okay, thank you, Your Honor. Upon the quick research I was able to do just now, it does appear that that would be an error, as the second offense was, that I counted, was a misdemeanor and not a felony. So it appears that Mr. Jennings is correct in that calculation.
All right, thank you, Mr. Cody. Mr. Griffin, do you have anything to add?
Your Honor, I count 2 felonies in addition to the sentencing offense, just on a review of the aegis description.
Go ahead.
It appears to me that quite clearly this defendant had, as was charged, an intent here, possession with intent to deliver methamphetamine. She was found with a baggie of methamphetamine, a scale, several plastic baggies, which is common in the drug trafficking world to give small portions as you sell it. She also had $1,230 in her possession in cash. And then she had a Xanax pill on her as well. I count those as 2 felonies. As they arrived in jail, she was informed if you bring anything into jail, you could be facing another felony charge. She then pulled out a meth pipe from her person, which I think is what supports the possession of methamphetamine charge. So I do see 2 other felonies in this case.
Mr. Jennings?
Thank you, Your Honor. Your Honor, I don't dispute Mr. Griffin's analysis in regards to the Xanax pill as being one extra felony. However, the meth pipe that was found was also part of the methamphetamine that she had in her purse. And so she had methamphetamine in the crystal form and the meth pipe, and I would I claim that that would be one crime, which is the crime, of course, that she's being convicted of today. As far as the delivery, there's, other than having cash, which is not against the law, I don't really see any proof that the court would require to take it for a fact as for a sentence that there's that she did deliver any methamphetamine. So I would argue that there's only one extra felony, and that OB 12 requires 2 additional felonies. Okay.
All right, in considering the challenge to OB 12, again, there are a number of scoring options, and this was scored on the basis of 2 contemporaneous felonious criminal acts. The agent, on further review, has indicated he believes it would have been scored in error. The prosecutor has argued that the description of the offense would support the scoring of OB 12. Counsel agreed that there is one scorable contemporaneous felony. I think the question for the court is on the prosecutor's argument whether there is sufficient facts to support a preponderance of evidence of the delivery charge. And relevant to the court is that there were 2 individuals whose behavior is described in this description of the offense. That there's a co-defendant. The scale that was mentioned was located in the other person's bag, and there was a significant amount of cash, but only $192 of it was located in Ms. Quinlan's purse. The other approximately $1,000 and some change was in the other woman's purse. There were some plastic baggies. I think there's certainly reason, or perhaps probable cause to support the conclusion that this is related, but from a preponderance standard, the court wouldn't find that those facts, when we can apportion them between the 2 women involved, here would support scoring. So I'm going to sustain the objection and order that OB 12 be scored at 0 points. That makes the total OB points 10, and OB level 1, I believe, D grid, we remain in A, OB level 2 is triggered by a 10-point score, and it would remain 10 points. Is that, you had some different math, Mr. Jennings?
I had, came out, well, maybe my software isn't working right, but I calculated that would be, OV would be level 1 by not having the 5 points. If the court calculates it differently, I'll accept that.
Yeah, and I guess we're looking at the Class D grid. There's no dispute that Ms. Quinlan is an A. When we look at the total OVs, OV 19 was scored at 10 points, and OV 12 at 0, that leaves a total of 10. And on the D grid, level 1 is 0 to 9 points, level 2 is 10 to 24 points, and so I think there still remains a 2 with the 0 to 9 point range, although there should be a correction to the total OV points being 10 rather than 15. Mr. Cody, do you have any disagreement with the court's, I guess, analysis of the grade here?
No, Your Honor, that's my understanding of it as well.
All right. Any further challenges, Mr. Jennings?
No, Your Honor.
Go ahead with argument.
Thank you, Your Honor. Your Honor, I'd like to ask the court to go along with the recommendations. Ms. Quinlan, it's a fair recommendation. It's pursuant to the plea agreement that she received a delayed sentence according to MCL 333.411. The probation officer is recommending several things that she has to do during probation that would, address substance abuse issues, and I do think that a lot of those are appropriate. I'd like to ask the court to go along for.
Anything you would like to say?
No, Your Honor.
Mr. Griffin?
Court's recommendation.
The guideline range is 0 to 9 months. This is before the court on a plea agreement that has a sentencing provision for a term of probation under section 7411 of the Public Health Code, which contemplates probation without a conviction, and the agent has recommended in accord with that. On review of the pre-sentence reports, it certainly does stand out to the court that Ms. Quinlan, you're 32 years old, you have very limited criminal history, and you appear to have some things going for you in terms of your education and your employment. I think those are very positive steps. What's obviously concerning is that you're old enough to know that you have dealing anything with methamphetamine is just not going to go anywhere good. And you really need to make a decision to change that path that you're on, or things will go downhill quickly. And I'm sure that you are aware from living in this community, but I can't emphasize to you enough how much those of us who work in the court system see happen to people who start using methamphetamine. And this is not a good idea to start this in your 30s, and you need to focus on the things that you've done to put yourself in a good spot in life. You've got a degree, you've got a job. So I would encourage you to terminate connections with people who are involved in this and don't become among them yourself. This type of probation, which I will afford you the opportunity for, is to have the opportunity to avoid a felony conviction. So you'll be subject to all the probation conditions that are set forth in the report. There's a 1-day jail sentence with credit for 1 day served. And there are some financial obligations that the court does order as well, which you can take advantage of community service to offset the vast majority of them. There will be a separate probation order that goes over all the things you need to do and not do. And so you'll be reviewing that and signing that to indicate your understanding of the probation conditions. There's also an order for fingerprints that I'm going to sign where you need to go to the Michigan State Police to get your fingerprints taken. We need to do that today following the sentencing. Do you have any questions?
No.
Mr. Griffin? And then Mr. Cody, what instructions do you have for Ms. Quinlan?
Instructions for Ms. Quinlan are to contact me on Monday, October 19th at 10 a.m.
Do you have Mr. Cody's phone number, Ms. Quinlan?
Yes, I do.
Are you sure?
Yeah.
Okay. So you got to call him on Monday. You got that? Yeah. I've signed an order dismissing the remaining counts on the motion of the prosecutor. And this is a copy of the order for fingerprints. Mr. Jennings, if you want to grab that, Ms. Quinlan, take that with you and go get your fingerprints taken. you have any questions?
No, Your Honor.
Counsel, is there anything further?
Your Honor, could I ask Mr. Cody, what's your phone number?
225-8227.
Okay, thank you. I have nothing else, Your Honor.
Okay, we're all set on the Mr. Ruiz,
This one's the hallway.
why don't you come on up, and then, is this Ms. Phillips speaking?
It is, Your Honor.
Okay, Ms. Phillips, why don't you come on up? This is People versus Phillips, file 2059156. Mr. Ruiz is here with Ms. Phillips. It's my understanding, Mr. Ruiz, that Ms. Phillips did not appear for the pre-sentence report, and so there obviously would not be one. Is that, do you have any different understanding?
Your Honor, I know that Ms. Phillips' grandfather was hospitalized. I'm assuming she didn't appear for the pre-sentence interview. She was aware that there was a packet of paper that she received that she had to fill out. She left the packet of paperwork in the hospital. I reached out to Mr. Cody to try to get that paperwork, but I think by the time I reached out and it trickled down, we were already a week and a half out from sentencing, Your Honor. So we're asking that the matter be reset so that she can meet with Mr. Cody and move forward. Given COVID, given the fact that she's never been in trouble before, and this is the first time that she's had to go through this process, I think it's been something she's not been used to.
Mr. Griffin?
The court's always very clear about the obligation after entering a plea. And if Ms. Phillips needs a reminder, she can hang around for another hour or two when we go through it at 10:30 with other evidence. So regardless if somebody's sick or not, the obligation was on her to obey the court's orders, and she failed to. So I'm not asking for a warrant or anything to hold her pending sentencing, but I do want to point out that I believe this violation of a court's order relieves us of our obligation to continue to agree with 7411. I'm not sure if we're going to take a contrary position to that. I want to wait and see what the PSIR says and what the recommendations are. But I do think that voids that absolute guarantee that she can withdraw her plea if the court can go along with it. Thank you.
Mr. Cody, what is Ms. Phillips' status with you or your office in terms of preparation for the pre-sentence report? What has she done or not done?
Miss Phillips did meet with me one time to receive the paperwork, and she did call me one time after that and left a message, but she was unreachable following that. I called her multiple times and couldn't reach her. And then, as Mr. Ruiz stated, within the last week and a half, it was noted that she left her paperwork or lost her paperwork. So a new set of paperwork has been sent to Mr. Ruiz's office.
So you need her to obviously get that, fill it out, and return it to you?
That is correct, Your Honor. And I would urge Ms. Phillips, if she should still have my contact information, to call me later today.
All right. I'm not going to do a warrant when Ms. Phillips has appeared here this morning and has done some partial compliance with the pre-sentence process, but Ms. Phillips, I do want to emphasize, as the prosecutor said, lots of things are confusing in life right now, but leaving and just not following through, it's not that complicated to know that you were supposed to talk to somebody, and it sounds like some things in your life may have resulted in the paperwork being missing, but I would like your behavior to be in accordance with everyone else's observation that being charged with a felony is kind of a big deal, so I want you to act like that. You understand what I'm saying? Now, you had some contact with Mr. Cody. What I'm going to order is this. I want you to call him today. His number, Mr. Ruiz, maybe you can write this down for her, but it's 225-8227. Call him today. And then get the paperwork from your attorney, and I want you to return that promptly.
Okay.
When, following the court's completion of the rest of its docket, Mr. Ruiz will get a follow-up sentencing date set, and send out a notice of that. You apparently have current contact information for Ms. Phillips and Mr. Ruiz?
Your Honor, Ms. Phillips has been in contact with me almost on a weekly basis, yes.
Okay. So when we get the new date set, you'll need to appear for that, and then make sure when you talk to Mr. Cody today, have a solid understanding of whether you need to do anything else besides complete the paperwork. Do you have any questions?
Yes, actually, is that his work phone number? Because I've tried calling his work like 6 or 7 times. I couldn't get a hold of him. I left a message one time. Could I get his cell phone number so I could,
That number, the 225-8227 is the best number to reach you. Is that right, Mr. Cody?
That is correct.
I don't know if you heard what Ms. Phillips said, but she said she had called that number and left a message at one point, and she felt she was having some difficulty getting an answer. If there's a voicemail left there, do you get those?
I received one call and one voicemail from Miss Phillips, but in today's time, we're on the phone quite a bit throughout the day, and it's not uncommon to miss a phone call. Unfortunately, if she doesn't leave a message, I am not going to know that she's calling. And as I stated before, I called her back multiple times, and she doesn't have a voicemail set up.
All right.
Your Honor, I also have Mr. Cody's email address. I can provide, as long as Mr. Cody's okay with that, I can provide that to Ms. Phillips as well, so that's a backup plan.
All right, but in general, I think Mr. Cody's indicated, call that 225-8227, and if he's not there, leave a message, and then he'll get in touch with you. Do you have any other questions, Ms. Phillips?
No, Your Honor.
Anything further, counsel?
No, no, thank you.
Okay, we're all set there. And I think then we're back to Mr. Jennings, but I don't see him. Mr. Griffin, would you mind stepping out and see if he's in the hall? Mr. Jennings, any progress on either of your clients appearing here?
Slight progress, Your Honor. I got a text from my office that Ms. Hassel she just called. She was quarantined by the health department because her sister has COVID, which is why she didn't show up today. I've not heard from Mr. Ludi.
All right, let's go on the record in Ludi. We're on the record in People versus Ludi. This is file 2058779. Mr. Jennings is here on behalf of Mr. Ludi, Mr. Griffin on behalf of the people. And this is set for sentencing. It's about 9:15. The sentencing was set for 8:30. Sometime shortly thereafter, the court had called the matter and Mr. Ludi was not here. But we've given some additional time to see if he appeared just before starting the record. Mr. Jennings, you informed the court that you have not heard from him at all this morning. Is that correct?
I did get a text from my office saying that his brother-in-law had passed away. I did respond by text to Mr. Ludi, informing him to contact our office, and he'd not contacted the office yet. So I'm not really sure what the situation is. All I know is that his parents are here, but they had not had contact with him either, from what I understand. And my office informed me that his brother-in-law passed away, and that's why he's not here.
Mr. Griffin?
One second, Ron. I'm just talking to Lieutenant DeRocher from the Sheriff's Office, and Deputy Rombeck of the Sheriff's Office this morning at 5:30 stopped the defendant while he was driving suspended. And he took him home.
We brought him home before we had court this morning at 8:30.
So the defendant was aware of his court obligations, so we would ask for a bench warrant.
Nothing else, Your Honor. I don't dispute what Deputy DeRocher did say, because he talked to me about that this morning as well.
All right, and I would note that, on the court's review of the pre-sentence report and the criminal history, this is kind of odd in that the plea was entered back in February, and then the sentencing has been continued a couple of times, I think because of issues with him appearing for the pre-sentence process. And then in the meantime, there have been arrests on a couple of other felony cases that are still pending, so there's not been any conviction to the court's knowledge, but there is another pending felony charge in this court for a UDAA, and then a similar charge that is, I think, still making its way through the district court process. And I think we did explore, there was also an MI at some point, but not an active one. So I'm going to authorize a warrant, and then we'll proceed from there.
Excuse me, Your Honor.
All right. Yes.
I'll point out that I think at least one of the adjournments was because Mr. Ludi was in treatment at up in Calumet, and to the best of my knowledge, he's still continuing sobriety.
All right, I'm hopeful that that's the case, because that certainly would be a positive development. Okay, I guess we're all set on Ludi then, and we'll go back on the record on Hassel. Okay, we are back on the record in the Hassel matter. I think, Mr. Jennings, you were just saying that you received some word, not clear exactly on how, but that she reported having been subject to a quarantine direction because of an affected family member.
Correct, Your Honor. Ms. Hassel had called the public defender's office, and what it says is that she informed our office that she is quarantined by the health department October 9th and 10th of 21. I'm not sure exactly how. My secretary's coding doesn't make much sense, but anyway, the bottom line is that she's been quarantined because her sister has COVID, and that's why she didn't show up at sentencing. I've not received any confirmation of that.
All right, Mr. Griffin?
Your Honor, I guess if we can just adjourn until later today, if she can appear on Zoom or the telephone, we can get this done.
Yeah, I think that's fine. There seems to be at least some contact this morning with a plausible reason why she's not present, and I would also note that she has not a very significant criminal history. So we'll adjourn this to another date, and then Mr. Jennings, and hopefully you can communicate with her before that, and assuming she remains healthy, we can convene this by Zoom or some other method. So we'll get a new date scheduled on that. So anything else on for
Nothing else, Your Honor.
Okay, we are all set on sentencing then. Thank you.
Did you get that? Is that Northern Class?
They
Oh,
are.
well, congratulations.
This is all on YouTube, so they're watching. This is being streamed on YouTube, so they're watching on YouTube.
More headaches?
Yeah, this is both of the same duties.
I made that shower this morning with my software.
not sure where Les is. So when trials begin, are they going to be back here at the Pettit and the veneer jury?
I mean, so far, we have people show up in groups and then ultimately see them back there.
Right.
And they can have this room or another room for deliberations and everything. So.
Okay.
It's gonna be weird.
Yeah, we'll get through it.
What are you gonna do? There's only so many options, you know?
Yeah, I know. Hey, Joe.
Okay, we are on the record in three files, People versus Gustafson. These are files 19, 58575, 576, and then 2059352. Mr. Cornell is here on behalf of Mr. Gustafson, and Sims is appearing by Zoom on behalf of the people. The court set these matters for status conference, a pretrial conference today. Each of these files has been set for trial and have been adjourned because of COVID-related delays. So the court issued an order back on September 17th requiring certain pretrial steps, and then would evaluate the status of those here. Mr. Cornell, I guess first issue, do you have any idea where your client is?
Thank you, Your Honor. No, I don't. I provided him with a copy of the pretrial order. Notices to appear that his attendance here this morning is required. I mailed it to his address of record 704 North Horseshoe Lake Drive in Gwynn. I have not received indication that He did not receive the notice. It did not come back to me in the mail, and I have not had contact with him by phone. Although I can advise the court that when we were here about that issue of bond modification allowing him to go back to Illinois, he indicated he was, even though he's allowed to, he's elected to stay here in the community because his wife is involved in a protected proceeding in the probate court regarding their child. And Mr. Gustafson is not a respondent in that case, but he is the custodial parent, and he wants to make sure that his child is here and can visit with his mother who is here. So my understanding is he's still in the area. I just haven't heard from him at all.
Does either of you know, counsel, whether he's involved in pretrial services?
I don't know, Your Honor.
All right, I guess I'll consider whether there should be a warrant issued for his failure to appear here today. But I guess looking at the other aspects of the pretrial order, I see that the defense has filed witness lists. Ms. Sims have the people?
Yes. Yeah.
When did those get filed? I don't see them in the file.
Yesterday.
Your Honor, if I could address that.
Go ahead.
I received copies of documents from Ms. Sims' office, but the case numbers were mixed up and there was apparently some confusion, and they were corrected by Jody Mallett this morning. And so I have received copies of the witness list. There's also exhibit list, and there's also a 404B motion attached.
Yes, Your Honor. What happened was I think the case numbers were right on the witness list, but they were wrong on the notices. They were all the same case number on all three notices when there should have been three different case numbers.
What's the 404B issue?
It's my understanding that Mr. Gustafson is going to claim that he had no knowledge of any drug activity, and I have prior convictions, including distribution of cocaine, that I would like to introduce to show that he is well aware of drug activity.
Are you seeking to introduce the convictions themselves?
I'm seeking to introduce testimony with regard to those charges, yes.
And I don't have the 404B notice here. I don't think it has made its way to the court file. Are you seeking to admit 404B evidence in each of these files?
Yes.
And what are the specific prior incidents that you're seeking to introduce through 404B? Or is there a list with the notice?
There's not a list. It's rather general, but I was looking to introduce evidence of his prior convictions when he was in the Air Force. He was engaged in an activity including distribution of cocaine, which is one of the issues on these cases right now.
But I guess just so I'm clear, are you seeking to introduce the conviction or witnesses testifying to the act?
I'm looking for the witnesses now, Your Honor. Dealing with the armed forces is not as cut and dry, so I'm looking to get some sort of evidence in regard to the activity.
The connection's not very good. I'm sorry. After you said dealing with the armed forces is not as cut and dry, then I lost you.
I'm sorry. I'm as close to my router as possible.
Your Honor, can I interrupt just for a moment? I'm sorry, Joe. I'm having a real difficult time hearing Jill. I mean, she's coming in like through two speakers and there's reverberations going on in the courtroom, and I'm hearing and understanding about every third word.
Yeah, I don't know if, usually your connection's pretty good, Ms. Sims. I don't know, do you typically use headphones or anything?
No, Your Honor, usually I'm in the courthouse. I'm quarantined now.
Oh my.
I can call.
I think what I'm going to do is just indicate that I would order a list of specific prior acts to be identified as a part of this 404B notice so that if there is a motion, then the court can make the evaluation of, whether the basis for disability is satisfied as to any specific prior act. With regard to Mr. Gustafson's non-appearance here today, Ms. Sims, what is the people's position?
I hope you can hear me. Mr. Gustafson has shown up to the protective proceeding. He always shows. I find it surprising he's not here today.
Your Honor, I have an update from my office.
Go ahead.
I've been informed that when Brandon from my office called Les, he said he can drop everything and be here in 30 minutes. Apparently the forms and my advice to him about showing up here in person wasn't clear enough for him, but just the same, he is in the area and he said he can appear if necessary. So I'd like to have the court excuse his attendance today.
Yeah, I think it sounds like a warrant's not really warranted, but counsel, I guess, given these various things, my intention is just going to be to find a new date in a few weeks with all of the same rules apply. And in the meantime, I'll do an order, Ms. Sims, that you should provide a specific description of these prior acts so we can deal with any evidentiary issues. My goal here, obviously, is we're not doing trials at this point, but I want to have cases that are fully worked up and ready. So if there is some motion that needs to be filed or hearings, get that done. And I also think that given the existence of these three files, I know there have been some negotiations. To the extent there's a potential resolution, I'd obviously like to, see if we can accomplish that as well. So let's just close the record for today. We'll find a new date, and then we'll go from there. Any questions or anything from your end, Ms. Sims?
No.
Mr. Canal?
I'm all set. Thank you, Your Honor.
Okay, thank you.
Court is now in session.
See, I have the Layton matter first. I see Mr. Block on Zoom. Are you doing Ms. Layton? Yes, I am. Would you come up and have a seat at this table? Right over here. Yeah, that's a gate on the side there.
Right here?
Right here.
I'm sorry.
So you can see your attorney.
All right, we are on the record in two files, People versus Layton. These are 2059302 and 303. Ms. Layton is here in the courtroom. Her attorney, Mr. Block, is appearing by Zoom. Mr. Griffin is here in the courtroom on behalf of the people. Mr. Griffin, what is your understanding of how we're proceeding here today?
Your Honor, my anticipation is a not guilty plea because Mr. Block and I heard from the defendant, so we've not prepared any paperwork. I don't know if that's changed, and we have other information, but that was what I was told.
Mr. Block, is it your understanding that Ms. Layton would be pleading not guilty to these charges at this time?
Yes, Your Honor.
All right. Ms. Layton, you're here in two cases, and in each one of them, there's an information or charging document that's filed. The information in file 59302 contains 6 counts, and it reads, in count 1, that you are charged with possession of methamphetamine, which is a felony punishable by up to 10 years in prison and with a maximum fine of $15,000. Count 2 charges you with possession of cocaine, which is a felony punishable by up to 4 years in prison with a maximum fine of $25,000. Count 3 charges you with possession of a controlled substance, which is a felony punishable by up to 2 years in prison with a maximum fine of $2,000. And on all of those controlled substance offenses, there can also be sanctions on your driver's license. Counts 3 and 4 charge you with a felony firearm, which is the possession of a firearm during the commission of a felony. And each one of those is punishable by a 2-year prison term, which is consecutive with and preceding any term of the imprisonment for the underlying felony. And count 6 charges you with maintaining a drug house, which is a high court misdemeanor, punishable by up to 2 years in prison with a maximum fine of $25,000. All of these offenses are alleged to have occurred on July 13th, 2020 in Nagani Township. In file 59303, the information contains 2 counts. Count 1 charges you with possession of methamphetamine, which again is a felony punishable by up to 10 years in prison and with a maximum fine of $15,000. And count 2 charges you with operating a motor vehicle while your license is suspended. And that's a misdemeanor punishable by up to 93 days in jail and with a maximum fine of $500. Your attorney has indicated that at this time you wish to plead not guilty to all of these charges. Is that correct?
Correct.
The court will enter not guilty pleas in these matters, and then counsel will set these for scheduling conference where you can determine what else needs to be set in these files. Is there anything else for the record at this point from the people's standpoint? Mr. Block?
Not for the record, but if I might briefly, Ms. Leighton, I've sent you a number of letters to 3 Boulderwood Court that came back. Is that not a good address for you?
They can't come back?
Yes, they came back to me.
That's strange.
Do you have a phone number?
Yes, I do. It is 906-250-0753. And is it possible to get your right phone number before I leave here by chance?
226-3328.
Thank you so much.
Mr. Block, did you say 226-3328?
I did.
I just wrote that down and we'll hand that to Ms. Leighton so she has that.
Thank you.
I note for the record that I had some communication from pretrial services regarding some positive screens, but also that Ms. Leighton has been in good contact with Ms. Peters and is pursuing some efforts to seek treatment. So I want you to keep your appointment, stay in contact with her, and follow through with that. Anything else we need to do at this point then, council?
No, Your Honor.
No, Your Honor. Ms. Layton, please call me today.
Yes, sir.
Thank you.
Do you have any questions, Ms. Layton?
No, not at the moment.
Okay, you're all set. Thank
All
you.
right, will I get something in the mail? Actually, I do. I'm sorry about like my next court date, or will I go through that with my lawyer?
You will get something in the mail. So typically the court will set the date for the attorneys, and then the attorneys send it to you, which is why I think Mr. Block was, questioning why he's getting mail returned. So maybe when the two of you talk on the phone, you can get that straightened out.
Yeah, most definitely. Well, thank you so much.
Thank you, you too. No, I'm trying to figure out, if it doesn't change me on the phone.
You sit in that chair over there, Casey.
Sir, are you Mr. Massey?
Yes, I am, Your Honor.
Go ahead, Massey.
Okay.
Huh? Yeah, this is David. St. David.
And I got the advice of rights I gave her. And I got the information too.
You already got it?
Yep.
I did jump to
All
Mr.
right, we
Casey.
are on the record in 3 files, People versus Massey. These are 20-59349, 50, and 51. Mr. Massey is here, which is attorney Mr. Jennings. Mr. Griffin is here on behalf of the people. We have these matters scheduled for a plea this morning, and I am in possession with a signed advice of rights form and amended information in each file, and then a signed plea agreement as well. The plea agreement contemplates a plea to 1 count in each file, and it would appear to the court that that would be count 2 in file 349, count 2 in file 351, and count 3 in file 350. Is that correct, counsel?
Yes, Your Honor.
Mr. Massey?
That's correct, Your Honor.
Could you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Mr. Massey, you're here, as I said, in 3 cases, and each one of them has an information or charging document. You've signed a plea agreement that suggests you'll be entering a guilty plea to 1 count in each case. And that would be count 2 in file 349, count 3 in file 350, and count 2 in file 351. Each of those is the same charge, which is possession of methamphetamine, which is a felony punishable by up to 10 years in prison, with a maximum fine of $15,000, and also the potential for sanctions on your driver's license. If you do enter these guilty pleas, you won't be having a trial. You'll waive all of the rights that are listed on the advice of rights form that you can sign. In addition to the rights that are listed on that form, if I accept your guilty pleas, you would give up the right to claim that the plea was the result of some promise or threat that someone had made that you did not disclose here in court, and the right to claim that it wasn't your own choice to enter a guilty plea. Do you have any questions about your rights?
No, ma'am.
All right, Mr. Griffin, if you would put the agreement on the record, please.
In exchange for the defendant's plea of guilty to 3 counts of possession of methamphetamine, 1 count per file, prosecution agrees to seek dismissal of all other charges pending in these files and not to bring any other charges arising out of these criminal incidents.
Mr. Jennings, is it your understanding of the plea agreement?
Your Honor, can I have a brief discussion with co-counsel here?
Your Honor, it is my understanding the plea agreement. I did have a discussion with the prosecutor regarding not proceeding against the defendant as a habitual offender. And to the best of my knowledge, and after discussing it with the defendant and with the prosecutor, Mr. Massey has no priors, so I don't anticipate any habitual notice either.
Is that your understanding as well, Mr. Griffin? Mr. Massey, is that your understanding of your plea agreement?
Yes.
Do you have any questions about it?
No.
Other than the terms of the plea agreement, has anyone promised you anything to get you to enter these guilty pleas?
No.
Has anyone threatened you?
No.
Is it your own choice to enter these guilty pleas?
Yes, Your Honor.
Starting in file 349, this charges you with possession of methamphetamine on or about August 4th of this year in the city of Ishpeming. What plea do you enter to that charge? Guilty or not guilty?
Guilty, Your Honor.
And what did you do on August 4th that makes you guilty?
They got pulled over on a basic traffic stop, and my passenger had an open intox, which got them to search the vehicle, and that's when they found the methamphetamine.
And did you know you had methamphetamine?
I didn't even realize that I was in the car because I didn't know I had my bag. I didn't realize that at the time. I knew I had it, but not in my car.
Okay. But at some point you had put it in your car?
Yeah, at some point I put my bag in there, yes.
Okay. In file 350, the charge in count 3 is possession of methamphetamine on or about October 8th of last year in the city of Ishpeming. What plea do you enter to that charge? Guilty or not guilty?
Guilty, Your Honor.
And what did you do back last October that makes you guilty of that?
That was a control buy to the CSI number.
And so is it your understanding that you had methamphetamine in your possession and gave it to someone else?
Yes.
And did you know that you had methamphetamine in your possession?
Yes.
In file 351, the charge in count 2, again, is possession of methamphetamine, and that is alleged to have occurred back on September 3rd in Ishpeming Township. What plea do you wish to enter to that charge? Guilty or not guilty?
Guilty.
And what did you do on that date that makes you guilty?
The same CI person presented him with methamphetamine.
And so was that another instance in which you knew you had methamphetamine in your possession and you gave somebody else?
Yes.
Counsel, is either of you aware of promises, threats, or inducements other than what's been disclosed on the record?
No, Your Honor.
I will accept these guilty pleas. They appear understanding, voluntary, and accurate. There's not a specific sentence agreement in the plea agreement. I am looking at a sentencing date of, this would be a Thursday. It's December 17th at 9 a.m. There are some DOC proceedings set that day, and so I'd like to get this one on that same date if we can. And before that date, Mr. Massey, in fact, when you leave here today, you should call the circuit court probation and parole office, and Mr. Jennings can make sure you have the right number. It's the 225-8226 number. You're going to be making an appointment with them for a pre-sentence interview, and they'll also send you a packet of paperwork that you need to complete. If you have any confusion in that process, make sure you let your attorney's office know so that we can get that straightened out and proceed with the sentencing then in December 8th. Counsel, to the best of your knowledge, has the court complied with the applicable court rules?
It has.
Yes, Your Honor.
Anything further on these matters?
Nothing else.
Do you have any questions, Mr. Massey, about what you need to do?
No, Your Honor.
Well, you know what? I think this might be a case in which fingerprints are needed. Let me see.
They printed me at jail.
I'll talk to you about it.
Okay.
You just have to go to the state police, but get your fingerprints taken. They don't use ink anymore.
You can take care of that, Mr. Jennings?
I don't have an order for it or anything. I don't know what.
I do not have an order in front of me, but I guess maybe I could ask Mr. DeSetto if you could check with Carol and see if there's an order, then Mr. Massey should do that. So they were supposed to take them to board, so we can kind of follow.
Okay, because yeah, when I went to jail, they took them, but that was not that was at the branch here, not at state police post.
Okay, we'll just wait and see if the clerk has an order.
No problem.
That's all I got, Your Honor.
Okay, then we can go off our record and just make sure I want to know what we need to do.
All right. Thank you, Your Honor.
You got, write this number down somewhere.
226, what, 8226? 226.
225.
Or 225, 8226?
8226.
I'm good with numbers.
Okay, now call that number. That's
Yep.
the probation
Yep.
clerk's number.
Okay.
And if she doesn't answer, you leave your phone number.
Yep.
And your mailing
Yep.
address.
I got changed all those already to most of them, so.
Is this up to date?
No, that isn't your office. I gave it to her. The girl gave.
Well, give it to me again.
801 North 3rd Street, apartment number 4.
In Marquette?
Ishmael.
Okay. Is this your phone number?
Yep, that's up to date.
How about this one?
That one, that's what I wanted to ask you about. The state, they have my phone. Am I getting that back?
Oh. Why don't we talk about that, okay?
Yep.
Try and get it back for you.
Yeah, because now I took it.
All right, so you make sure you call that number and you leave your phone number, your mailing address, and, and your name, of course.
Yep, yep.
And then tell her that, just to mail stuff to that mailing.
Okay.
Okay?
Yep.
You're gonna get a packet in the mail, and then just fill out the packet, and if you got any questions about it, you give me a call, okay?
Okay. Yep.
Do everything else I was telling you.
Yep.
Okay? And I'll see what I can do about getting your phone back, probably not till next week.
Yeah, that's fine.
Okay?
Awesome.
Well, hold on a second here.
Okay.
Are we doing the April matter?
Hang on just a second.
Yeah, Huh? Oh, she's on Zoom? Oh, okay.
Okay, here's the personal fingerprints, and this is just to the sheriff's department, not the state police, so I don't know if there were different agencies involved, but because of there, that should take care of that. So I think we're all set.
You know where the sheriff's office? Well,
Yeah. So they need them again? Okay.
Yeah, go over there.
Yep.
They'll do your fingerprints.
Okay.
And then, just give me a call next week or two and let me know how you're
For
getting
sure.
along.
All right. Sounds good. Thank you.
Okay.
You got a signed statement on this, April? There's one?
Yeah, I think. Yeah, go ahead, leave.
All right, thank you.
I got advice of rights.
And here's your copy.
Oh, thank you. Again. Okay. Actually, I got the updated advice of rights.
It looks as if the April is connected. There was a brief video appearance, and then that went out, and it's trying to connect to audio. It looks like she's in the phone.
There we go.
All right, Ms. April, this is Judge Mizuki. Can you hear me?
Yes, I can, ma'am.
Okay. We are on the record in People versus April. This is file 2059375. Ms. April is appearing by Zoom. Her attorney, Mr. Jennings, is here in the courtroom. Mr. Griffin is here in the courtroom on behalf of the people. We have this matter scheduled for a plea today, and I do have a signed original plea agreement and a signed advice of rights form as well. Counsel, anything preliminary before we go ahead with the plea?
No, Your Honor.
No, Your Honor.
Ms. April, could you raise your right hand, please?
Yep. Hold on. I'm holding the phone with the right hand.
Do you swear or affirm the testimony you're about to give will be the truth and nothing but the truth?
Yes.
Okay, you can put your hand down. Ms. April, you're here charged with one count of possession of methamphetamine, which is a felony punishable by up to 10 years in prison and with a maximum fine of $15,000 and the potential for sanctions on your driver's license. The plea agreement that you signed indicates you'll be pleading guilty to that charge under the terms of the plea agreement. If you do that and I accept your plea, you would give up your right to trial and all of the rights that are listed on the advice of rights form that you've signed. In addition to the rights that are listed on that form, if I accept your guilty plea, you would give up the right to claim that the plea was the result of some promise or threat that someone had made to you that you did not disclose here in court, and the right to claim that it wasn't your own choice to enter a guilty plea. Do you have any questions about your rights?
No, I do not.
All right, Ms. April, I'm going to ask the prosecutor to say what he thinks the plea agreement is, and then I'm going to ask your attorney, and then you, if everyone has the same understanding of that agreement. Go ahead,
Okay.
Mr. Burke.
Your Honor, in exchange for the defendant's plea of guilty to possession of methamphetamine, prosecutor agrees not to bring any other charges arising out of this criminal incident, not to proceed against the defendant as an habitual offender, and to delay pursuant to MCL 333.7411.
Mr. Jennings, is that your understanding of the plea agreement?
That is correct, Your Honor.
Ms. April, is that your understanding of your plea agreement?
Is that with the delayed sentence of probation?
That's right, it's a deferral of conviction, so it's not a conviction and a non-public probation. Is that what you understand?
Yes.
Yes. Do you have any questions about it?
No, I do not.
No. Other than the terms of the plea agreement, has anyone promised you anything to get you to plead guilty?
No.
No. Has anyone threatened you?
No.
No. Is it your own choice to enter this guilty plea?
Yes, it is.
Yes. On the charge in count 1, possession of methamphetamine on July 9th of this year in Ely Township, how do you plead, guilty or not guilty?
I'm sorry, go ahead.
On the charge of possession of methamphetamine from July 9th of this year in Ely Township, how do you plead, guilty or not guilty?
Guilty.
What did you do that makes you guilty?
I had a meth pipe in my purse.
And did you know that you had some residue of methamphetamine in the pipe in your purse?
Yes.
Yes. All right, counsel, is either of you aware of promises, threats, or inducements other than what's been disclosed on the record?
No, Your Honor.
No, Your Honor.
I will accept the guilty plea. It appears understanding, voluntary, and accurate. The plea agreement contemplates a deferral of conviction under 7411, and so it's accepted without entry of a conviction at this stage. I'll set sentencing for December 17th at 9 a.m. Prior to that time, Ms. April will participate in the pre-sentence interview process. So Ms. April, we have your sentencing in December, but later today, I need you to call the probation and parole office to make an appointment for your pre-sentence interview, and they're going to send you some paperwork that you need to fill out also. Do you have a writing down phone number right now?
Yes.
Yes. You need to call 225.
Okay, hold on. I'm going to put it on my phone right now. I'm using someone else's phone, so. Let's see. 225.
8226.
225. 8226.
8226.
Okay.
Okay, 225-8226. So call them today, and you'll get set up with your pre-sentence process. If you have any problem in doing that, call your attorney's office, and they can help you straighten it out.
Okay.
Counsel, to the best of your knowledge, has the court complied with the applicable court rules?
Yes.
Yes, Your Honor.
Anything else on this matter?
No, thank you.
Nothing else. I'd just like to talk to my client briefly.
Go ahead.
Less than 30 seconds. Okay, Jennifer, you call that number 8226.
Okay.
If there's no answer, or I'm sorry, if you leave a message with your correct phone number and make sure you tell her your correct mailing address. Okay? Because that way she'll send stuff to you in the mail. Okay? And make sure you follow through with everything. And if you got any questions, you give me a call, okay?
What? My bond money, do I get that back?
You'll get that probably at sentencing, okay?
Okay. What happened?
All right?
Okay.
And you can call me next week if you got any questions about that.
Okay.
All right, you can hang up now.
Patrick Crowley, my attorney.
Yeah, there may be some confusion, and Mr. Jennings, maybe you could just speak to Mr. Green. Mr. Jennings is in the office with Mr. Crowley. The court had the understanding that the hearing matter was either adjourned or waived. In the Zoom waiting room has been someone from the Attorney General's office, who I think is the prosecutor on that case. And so I don't know whether there's some confusion about that, but if you want to stay where you are for just a minute, Mr.
Yes,
Herring, Mr. Jennings, maybe you could contact Mr. Crowley real quick and make sure that Mr. Herring knows what he needs to do.
Sure.
Okay.
I'll be right with you. I work in the same office with
Yeah,
Ted.
do.
You want me to hang on?
Well, we have the Patterson one, I think.
Oh, that's just an, what's his story? He's Patrick's client, and he might be here for AG prosecution.
Come on out in the hallway.
Okay.
Okay, we are on the record in the Patterson matters. These are files 20593798081. Mr. Ruiz is appearing by Zoom on behalf of Mr. Patterson. Mr. Griffin is here in the courtroom. I don't see any connection from Mr. Patterson. Mr. Ruiz, I have some indication from the court staff that this might be a waiver. What's the status?
Your Honor, I did intend it to be a waiver, but I've not been able to get a hold of Mr. Patterson.
Did you say you intended to submit a waiver?
Correct, but I've not had a chance to get a hold of Mr. Patterson to sign one.
Okay. I think what I'm gonna do is just set this for an adjourned arraignment, then I'll just send a notice for the next scheduled arraignment docket that the court has, and then if there's a waiver before then, that's fine. If there's not, then we'll address, compliance with any pretrial issues, but we'll at least set it for one more follow-up date before we do that. Anything for the record from the people?
No, thank you.
Anything from your standpoint, Mr. Ruiz?
No, Your Honor, thank you.
Okay, thanks, we're all set.
Did you need me to hang around in case there's an AG issue?
I don't think so, but thanks for the offer. We will hang it down if we need to. I think there was a waiver or an adjournment that the guy didn't know about or something like that. Okay, thanks. Oh my gosh. Thank you.
Would you like Ms. Schultz to come up there immediately, or?
You know, why don't you just, Ms. Schultz, Ms. Nelson, if you and Ms. Schultz could just be seated at this table, and she can stay put for testimony.
Okay.
Okay, we are on the record with Macker Joshua Schultz. This is file 18-34081. Ms. Nelson is here in the courtroom on behalf of the people, and she's accompanied by the petitioner, Ann Schultz. This is scheduled as an emergency hearing on a request for an order for examination and transport, and I have reviewed the petition. Ms. Nelson, I assume you present testimony from Ms. Schultz?
Yes, Your Honor.
Ms. Schultz, raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth and nothing but the truth?
I do.
Okay. You can put your hand down. Go ahead, Ms. Nelson.
Thank you, Your Honor. Ms. Schultz, did you file a petition for mental health treatment for Joshua Schultz? I did. And who is Joshua Schultz? My son. Okay. And the information on here in terms of his birth date and his address is correct as far as your personal knowledge goes? It is. Okay. On the petition, you've indicated that it's your belief that Joshua Schultz has a mental illness. Is that correct? Absolutely. Are you aware that he's been diagnosed with a mental illness before? Yes. And what do you believe that that diagnosis is? Schizophrenia. Schizophrenia. And to the best of your knowledge, has he been hospitalized previously for mental health treatment or mental health issues? Yes. And when was the most recent? I believe about a year ago. And where was that at? Down in the Sioux. Okay. I'm sorry, did you say down in the Sioux? Yes. Okay. And how long, do you know about how long he was at the hospital in the Sioux? I want to say about a month. Okay. And is it your belief that he has worked with pathways before? Yes. Okay. On the petition, you've indicated that you believe that as a result of mental illness, Joshua can reasonably be expected in the near future to intentionally or unintentionally seriously physically injure himself or others. Can you tell the court why you believe that that's true?
I witnessed him with marks all over his stomach and legs, cuts, his hands, I've seen his hands and feet covered in blood. He had a lump on his head. He had a burn mark on his stomach where he told me he had put a cigarette butt over himself. He had his door in his bedroom had been punched. There were plates as well as ashtrays that were broken and all over the place on this floor table. I had him at my house on Monday for approximately 3 hours. After that, he had left and was picked up by the Ishmael police for physically hitting a girl.
Okay, and when you had stated that you had seen him with the cuts and covered in blood, how recent was that?
A couple days.
A couple days ago? Mm-hmm. Okay. And you said that he was also arrested for assault.
Yes. Yes.
And that was just this past Monday, correct? Okay.
It would have been Tuesday morning at approximately 2:30 in the morning.
That he was arrested for the assault? Okay. You've also indicated on the petition that you believe that he's unable to attend to his basic physical needs. Is that correct?
That is correct.
And what is some information you can tell the court as to why you believe that that's true?
He hadn't showered or changed his clothes. He refused to shower. I tried to talk him into taking a shower at my house when he was there. All I got him to do was wash his hands. He said he didn't need to eat, that he was going to be becoming a model, and I didn't get him to eat, but he hasn't been buying groceries with his food card. I've been doing that because he wasn't doing it. Normally he spent it within 2 days, and he hasn't done that.
And does he have some type of medical issue with his hand?
He does. He has an infection in his hand, which is not in his bloodstream.
Okay, and how did you come to know that information?
I got a call from a police officer, my husband Red, telling me that he was on his way to a homeless shelter. This was prior to us even knowing that he had been arrested for the assault.
Okay.
So he made a phone call, like he had a ride home from being released to Pathways, and he didn't, and he went down to the Mexican restaurant, Solis Teca, was hanging out there. Apparently he wouldn't leave, somebody fed him. The police showed up on another business owner's phone call, saying that he thought he needed to be brought to the shelter. So they were informing me that that's where he was going. He did go there, and it was in Harvey at a church. In the middle of the night, he left. Apparently, he was trying to fight with everybody there, and he left with some known drug users. So I was told by the coordinator of the place.
Okay.
And I later learned that they had been sleeping behind the Econo Foods parking lot, and they were sleeping in a manhole. I think that's where his shoes got left. And they found him at the Holiday gas station approximately 3:30 that day.
And that would have been on Wednesday?
I believe so.
Wednesday,
Yes.
okay. Has he also said anything that recently that's caused you concern?
Yes.
What is that?
Monday while he was at my house, he was saying that he had fought God and the devil, and he had won. He put his hands on my husband and said, "You're a good man, I think I'll save you." He sat in front of my theater talking about my younger son, saying that his eyes were already gouged out and that he had flesh falling off of his arms. He kept following me in the house. He wouldn't sit down. He was very agitated. When we were on the way to my house, he kept clenching his fist and looking at his arm. And at one point, he reached about the seat in the front. He told me he was just wanting a cigarette, but it's my understanding that that's what he did prior to hitting the girl.
That he was arrested for?
Correct.
Okay. And you've actually seen him today, is that correct?
I have.
And did you ask him to go to the hospital voluntarily for mental health treatment?
I did.
And what was his response?
No.
And you've also indicated on the petition that you believe his judgment is impaired by mental illness such that he is allowed to understanding for his need for treatment, is that correct?
That is correct.
And is that based on his unwillingness to go to the hospital?
Yes, it is.
Is there any other information that you're basing that opinion on in terms of your beliefs?
I don't know what you mean by that.
I guess is the fact that you believe he's unable to understand his need for treatment. Is there any other facts that you would want the court to know in terms of why you believe that?
I just don't think he's in his right mind right now.
Okay. And again, you've asked him as recently as an hour or
Yes.
so ago to go to treatment?
Yes.
And he refused?
Yes.
And so you are asking the court to issue an emergency pickup order, is that correct?
Yes.
And you're also asking the court to have Mr. Schultz hospitalized pending a hearing, is that correct?
Yes.
I have no further questions for Ms. Schultz, Your Honor.
The one thing I'm confused about, Ms. Schultz, I guess, so I understood from your testimony that he had been admitted to the hospital and was awaiting airlifted, and that's when he left against medical advice? How is it that he came to be admitted to the hospital?
Initially, I came to the court here and I spoke with Diane Heighton and I was trying to petition and she said I would have to have him ask him verbally, someone would have to ask him if he was willing to go. Nobody knew where he was at that time. So when they picked him up, they brought him to the hospital. They asked him if he wanted to go to the hospital and he said yes.
Okay.
So he voluntarily went to the hospital. I was contacted by the ER doctor to come in and sign a petition, which he said he had enough evidence physically and psychologically that he should be hospitalized with the infection in his hand. But apparently, he'd never been evaluated psychologically.
Okay. So he was admitted, as you understand it, for the physical ailment, he then left against medical advice, and that was just earlier this week?
This was last night.
Okay. Anything further, Ms. Nelson? All right, this is before the court on a request for an order for examination and transport. I would note that this is a 2018 file, and the court reviewed the register of actions before coming on the record, and there is documentation in the court records that Mr. Schultz has been the subject of prior petitions, and that is further supported by the testimony from his mother that he has had a diagnosis of schizophrenia and has undergone treatment voluntarily and involuntarily in the past, has also previously had a pathways case. The court is satisfied from the testimony that there's also been observations of Ms. Schultz, who's presented very credible testimony here about a number of aspects of concerning behavior and apparent lack of understanding the need for treatment, lack of judgment, lack of attention to basic needs, and then statements that appear inconsistent with reality. There's also some evidence of some significant physical health issues that have warranted treatment and documentation of infection, and then a departure against medical advice. So there have been significant efforts to obtain his consent for an admission and examination for psychiatric purposes. So I am signing an order for examination and transport on the form proposed by the prosecutor, and it is valid for 10 days from today. And I think Ms. Nelson, obviously I'm substituting for Judge Hill today. My understanding is that we'll get a true copy of this and then give it to you, and you would take it to the Sheriff's Department. Is that the process from your standpoint?
Yes, sir. I will take the original over to the Sheriff's Department and answer any questions that they may have.
Okay. So I will go bring this file then to my administrative aide, and Ms. Schultz, if you could just hang out in the hallway for a couple minutes. Ms. Nelson will help you get this processed, and I hope your son is okay.
Thank you very much.
All right, thank you, Elsa. So I think this is all good. Mrs. Schultz is going to sit in the hall. I told Jenna you could get her like a true copy or whatever, just a sample or something of that, and they'll take it from there.
Okay.
Okay, thanks.
You want to come yeah, I do have a couple of 30s with you.
Oh, yeah, that's fine. I'll just wait till you're back in, because
Okay.
there's some other people having to, I think.
They do, okay, perfect, okay, thank you.
Matfield? I thought I heard your Cody's voice somewhere, yeah. Okay, we are on the record of Matfield matters. These are files 19, 58487, and 888. Matfield's here with Ms. Fountain on his behalf. Williams here on behalf of the people. The court set these matters for pretrial conference today. These are among the cases scheduled for trial on November 3rd. We're, of course, continuing to evaluate things in light of the COVID status, but the court would like to have cases ready to go at any pretrial matters taken care of on the date that the trial is to commence. And so prior to today, the court ordered that counsel confer and deal with any evidentiary issues and be prepared to advise the court of where things stand here. I would also note that witness lists, I think, we have a review on the 3rd and jury instructions will be due on the 18th. Mr. Griffin, I guess starting with you, what's your understanding of the status of these matters?
Yeah, Ms. Feldman and I did discuss this morning, and we made an updated offer that we both believe is probably going to settle it. Ms. Feldman indicates she wants to run some guidelines to make sure first. Perhaps we can set this for agreement next week.
Just for the record, so we're all on the same page, what is the updated offer?
Plea to possession of cocaine less than 25 grams is an habitual offender's second offense. It's my understanding that this would open the guidelines up between 2 and 21 months as a range, as opposed to the prior offer, which was 9 to 23.
And maybe it doesn't make any difference, but is that as a regular habitual offender statute or the second offense controlled substance?
Regular habitual.
Okay.
Otherwise, it would have to double the guidelines.
Okay. Ms. Fountain, and then, having gotten this recently, obviously, we need to discuss it with Mr. Matfield, but do you concur with Mr. Griffin's assessment that this is a likely resolution?
I do, Your Honor. I also want the opportunity to speak to Mr. Mason, who had previously been my client's parole agent, and kind of see where he's at on things. I think this could potentially resolve it. My client's been out on bond for, I believe, a little over a year at this point.
Yeah,
and
2019 cases, so yeah.
And is doing very well out on bond. So I'm hoping that this could potentially resolve it, depending on what Mr. Mason anticipates.
Why don't we, counsel, do this, if this makes sense to you, I guess. Let's just keep the trial date set as a, well, let's say, we have several things that are scheduled for Thursday, October 29th. And I'm wondering about adding this to that schedule at 11:30 or 11:45. I think you're here on some other matters, Ms. Fountain, and I think you or one of the other prosecutors are here as well, Mr. Griffin.
Works for me, then.
That'll work for me, Your Honor.
Okay, so let's just set this tentatively anyway, Thursday, October 29th at 11:45. And then for Matfield, obviously, I certainly would like you to talk to your attorney about all your options here, but I want you to have adequate time to consider this, of course, before you make a decision. So we'll set this as a tentative date, Thursday, October 29th, 11:45. And then, also, I guess if you need any further conference with the court prior to that time, then I can hunt you down and we can do that. Anything else for the record on these matters?
The other thing I'll add is, according to my notes, the court did indicate if he continues to do well on bond, it would not be looking at prison time, and that was part of our discussions this morning as well. But the concern was to keep the guidelines lower for potential lower sentence as to any jail time.
Okay, and I thank you for reminding me of that, because honestly, we've had some of these discussions, and that sounds like something I would say if I never remember that. So if there is, the length of time that Mr. Matfield has been on bond, if there were a guideline range that makes that seem reasonable and is in keeping with his performance, I
No, Your Honor.
Okay.
Now they can get updated.
We're gonna go over the bar table over there. Jennifer, you sit in that chair right there.
I wonder, Mr. Jennings, I see this is Ms. Hagan's, but I know that Ms. Nelson was handling a couple of these, and we just had an emergency MI, so she may be right back. Do you know who from the prosecutor's office was going to do this?
For the MI?
No, for this case with your client,
Oh, me.
from the prosecutor's office.
Oh, from the prosecutor.
If you
I think
know
it's
this,
Dodie.
I'm just wondering what.
Dodie's
Okay, well, let's take a short break. I'm gonna see if she's coming, or I was saying that Ms. Nelson, I just did an emergency with her, she had to take some paperwork, so if she's covering it, then that might be what the prosecutor here.
Let me call down there and find out.
So I'll ask Carol to check on you.
Okay. Sorry, I couldn't keep track of who all the players you were talking about.
A lot going on here this morning.
Yeah.
Hey, Megan, is it cool if I just sit out there and drink my Red Bull?
Yeah, go ahead.
I keep crazy. So, are you still living with your husband?
No, me and David have not been together, and
Yeah,
he's in
didn't he
jail
just-
right now.
Yeah, didn't he just give you a ride that time?
Yeah, I literally had been in the car.
go up this way. Now this guy.
This way. Here.
We are on the record in People versus Polkinghorn. This is file 19-58453. Mr. Polkinghorn is here. Mr. Ruiz is appearing by Zoom on his behalf. Mr. Sullivan is appearing by Zoom on behalf of the people. And we have this matter set for a motion hearing today. Mr. Ruiz had filed a stipulated motion stipulated between himself and his client to ask the court to permit his withdrawal on this matter. Mr. Ruiz, go ahead with anything you would like to say about that in addition to what you put in writing.
Your Honor, I've got nothing further to say than the stipulation withdrawal. Mr. Porkinghome's looking to move on, and I wish him the best of luck.
Mr. Ruiz, are you appointed or retained?
Retained, Your Honor.
Mr. Sullivan, do the people have a position on the motion?
No, Your Honor, we don't oppose withdrawal of counsel at this point. I suppose we would ask the court to inquire if Mr. Polkinghorn is going to plan on either representing himself or obtaining other representation, so we know who we can speak to about this case.
Mr. Polkinghorn, you're here in the courtroom and you have been here for some time here. I see that you signed this motion joining in Mr. Ruiz's request for withdrawal as if you want the court to allow you to withdraw. Is that correct?
Yes, Your Honor.
And Mr. Ruiz, I asked if he was appointed or retained. He said he's retained. If he's not your attorney anymore, do you intend to hire your own attorney and someone else, or would you be asking for the court to appoint an attorney for you?
I'm not looking to have the court give me one or retain one at this point. I feel like I can resolve this matter on my own.
You intend to represent yourself?
Yes, Your Honor.
Okay. Credit to what the court rules say, Mr. Polkinghorn, is that if a person wants to represent himself, that the court should make sure that you understand, the risks of doing that and some of the difficulties of this. So let me go over a few things with you here. So, first of all, the information that's been filed in this case has 3 charges in it. The first is resisting and obstructing a police officer, and that is a felony with a maximum penalty of 2 years in prison. The other 2 charges are misdemeanors. One is operating while intoxicated, and the other is open intoxicants in a vehicle. The operating while intoxicated is a 93-day misdemeanor, meaning that is its maximum term, and the open intox charge is a misdemeanor punishable by up to 90 days. There's also, of course, various consequences for your driver's license, potential vehicle mobilization, and so forth. Also filed with the information is a habitual offender or supplemental offender notice, and so it says that you have previously been convicted of a receiving and concealing offense back in 1999, and because of that, the maximum term would increase from 2 years for the resisting and obstructing to 3 years, which is 1.5 times its statutory penalty. The reason I'm going over the charges with you here is that, do you understand the difference between a felony and a misdemeanor?
Yes, Your Honor.
One of the differences in terms of sentencing is that felony sentencing is governed in part by the sentencing guidelines. There's a need to calculate if a person is convicted what the recommended sentencing range would be, which is, of course, advisory to the court. Do you have any familiarity with the sentencing guidelines?
Yes, Your Honor. I understand it's like a point system based on my past charges and this and that.
And have you ever had occasion to review them?
Review
The sentencing guidelines?
No.
Have you, would you intend to conduct a trial in this matter?
Yes.
And do you understand that a trial is governed by the rules of evidence? That is, there are certain things that you're allowed to do, certain things you're not allowed to do. And people who represent themselves, I obviously approach it with some understanding of the fact that you're self-represented, but you're still subject to those rules. You understand that? And And you also would be required to participate in the jury selection process and exercising challenges and asking questions of prospective jurors. Do you understand that?
Yes, Your Honor.
And basically, the Constitution says both that you have a right to represent yourself if you want to, and that you have a right to be represented by an attorney. It is totally up to you which one of those things you pick. What I want to know is that you understand there's a lot of kind of technical things that have to be done in a case, and that if your liberty is at stake here, that you are making an educated decision to represent yourself. What questions do you have about what I said?
I don't have any questions, Your Honor.
Okay, and so you're joining in the request to have Mr. Ruiz withdraw, and further, you would intend to represent yourself.
Yes.
Okay, let me make sure then that we have the proper contact information for you so that we can mail court notices directly to you. What is your mailing address?
32 Sunnyside Estates, Ishpeming, Michigan, 49849.
And is that your own residence or is that in care of someone?
That's my residence.
Okay, and what's your phone number?
906-362-0282.
How far did you go in school?
College.
College? And so you have the ability to read and write?
Yes.
Do you have any, are you under any court orders regarding mental health or having a guardian appointed for you?
No.
Anything like that? So it's 32 Sunnyside Estates and then it's 362-0282?
Yep.
So, what I'm going to do then is sign an order permitting withdrawal and then indicate that Mr. Polkinghorn has elected to represent himself. Because of the withdrawal relative to the trial date, I'm going to, on my own motion, adjourn that trial date and we'll get a new date set. And what I'm going to do, Mr. Polkinghorn, is set a status conference in this case for probably in about 30-45 days. We'll send a notice to you of that, and you can participate by phone or Zoom. We'll send instructions for that also.
Okay. I have an issue I'd like to address. It has to do with the felony charges because it invoked a 1-year suspension of my license, and that license that year is already came and gone. And even though my license isn't good, they won't issue me a license. There's some hold on it. I'd like to address that because I mean I've done my year suspension. It's actually been 15 months, and the Secretary of State says it's some hold that's put on this side, and they won't issue me a license. I did my 1-year suspension.
The court hasn't made any orders about licenses.
Well, no, it invokes it. Okay.
And so, and this case is still pending before the court. So, if there's something that you're asking the court to order, what you need to do is file a motion, and in the motion, I would need you to cite the authority that allows the court to take action. And that is, the court can't just order whatever it wants. It has to have some authority to do that. Some licensing things happen through an administrative process through the Secretary of State, totally independent of the court. And so, it's not clear whether the court would have authority to do anything that you're asking, but if you want the court to do it, get a motion filed and we'll have it in the morning.
Can't this be an oral motion? Then no? Okay.
Do you have any other questions?
No, other than are we having the pretrial conference too right now?
We are not we're doing the motion right now, and what I just said is that on my own motion, I'm gonna set this for a later trial date because of the withdrawal of counsel close to the trial. So there will be due dates for things like witness list, proposed jury instructions, proposed order questions, and so forth. So I'm setting this for a conference in, as I said, like 30 or 45 days, and we'll set some dates.
Okay.
Okay. Any other questions?
No, I'm good.
Mr. Ruiz, Mr. Sullivan, anything further?
Nothing from the people, Your Honor.
Nothing, Your Honor.
Okay, we are all set for today then, and Mr. Polkinghorn will send a notice to you of any of this follow-up date. If you don't get something from the court in the mail within like a week or so, call the court and we'll figure out what the problem is.
Oh, so like all my file and stuff, can Tony just send me my old file? I think we had.
Yeah, I can send you everything, Derek.
Thank you, man.
Okay,
Yep.
thanks.
All right, bye.